Welcome to AD Dictation. Please subscribe the channel and hit the bell icon to get latest updates at first. If you have any query, then please let me know in the comment section below.
Ready, start. Contention raised by the council for the applicant is that PW1 was suffering with a serious ailment like chikungunya, and so he could not examine himself in the court on a few dates, and adjournment was sought and also granted by the court. But later on, at some stage, the adjournment was refused and evidence of PW1 was closed in the midway. This closure of his evidence is likely to cause serious prejudice to the interest of the prosecution. Another submission is that the statement of PW2 also appears to have been misplaced, and in place of it, some carbon copy is said to have been kept on the record, and that also speaks about the high irregularity which has crept into the proceedings, and in that regard, the statement of PW2 needs to be recorded again, but the presiding officer seized with the matter is not acting in accordance with law. Therefore, the proceedings should be transferred to any other court. Para. While rebutting the submissions placed by applicant's counsel, it was pointed out by Sri Rahul Chaturvedi, learned counsel for the opposite party number 2, that the matter has already reached at its terminating stage and the transfer application has been moved only with the object to scuttle and stall the proceedings. Moreover, if the applicant felt aggrieved by any of the orders passed by the court below, they should have been challenged before the superior court, which has not been done so far, and instead of challenging the judicial orders passed by the court below in a superior court, the applicant has jumped the gun and choose to move the transfer application, which does not appear to be a justifiable course. It was also pointed out that the accused are in jail and any unnecessary prolongation of proceedings will seriously prejudice the rights of the accused. Para. All the contentions which have been placed by the applicant's counsel appear to be in the nature of criticism of the orders passed in judicial capacity by the trial judge. If any order makes the applicant aggrieved, he should have challenged the same in the superior court, adopting proper legal recourse, but the same does not appear to have been done. A judicial officer may pass a correct order and may also pass an incorrect order. That is how and that is why superior courts come into play to look into the correctness of the subordinate court's order and then pass appropriate order with regard to the same. Different courts, like the courts of revision, the courts to entertain applications under section 482 CRPC, the courts to exercise powers to issue writs, etc., with separate jurisdictions have been carved out to exercise such respective jurisdictions in the High Court. But passing of the incorrect orders, even if it is presumed that the same has been done, does not constitute a legitimate ground to transfer the trial. Para. While exercising the jurisdiction of transferring a trial from one court to another, this court does not deem it fit or even proper to adjudicate upon the legality or otherwise of the orders passed by the court below. There is hardly any material available on the record which may indicate that the presiding officer is or was acting unfairly or dishonestly or was acting with prejudice or was influenced by some extraneous considerations, and therefore this court feels disinclined to interfere or to proceed to transfer the trial. The alleged incorrect or the illegal approach of the trial court must reflect that the same owes its genesis to some extraneous extrajudicial factors which may be said to have trained the judicious approach of the judge. Unless such a possibility appears plausible, this court ordinarily does not feel persuaded to exercise powers under section 407 of CRPC only on the ground of the trial judge having passed some incorrect order. Stop.